Let's get started. Ready? Welcome to the second Family Child Care Rules Advisory Committee meeting. We really appreciate you making the time to attend these meetings, especially after your long work day. My name is Carol Peterson, and I'll be facilitating this session tonight. And I want to quickly introduce the other DELC staff in attendance. So we have Abby Strom, who is monitoring the chat and is a subject matter expert. So questions can be sometimes referred to her. Allison Delory, she's our incredible note taker. And then we Okay, thank you. And then we do have a CCLD regional manager for the Tualatin office, Christina Austin. So as you get settled, if you could Okay. Thanks. Okay, as you get settled, if you could please confirm your name is correctly displayed on the participant icon, that's super helpful. We just want to ensure we capture all participants' names correctly. And as a reminder, for transparency purposes, this meeting is in webinar format, and all comments made either verbally or typed into the chat are considered public record. To ensure all input and voices are heard, any comments placed in the chat will be read aloud. You may want to confirm your message setting in the Zoom chat feature is set to everyone. That's just to ensure your comments display correctly and are included in this meeting. Please feel free to indicate in the chat whether you agree with a comment that was stated, so we have a good idea of how many people supported either the thought or the recommendation. So to kick us off, I'm just going to go briefly over the meeting agenda for our time tonight. We're going to start by reviewing group norms and the family child care scope for this RAC. We're going to review feedback and responses from the previous meeting. We'll dive right into reviewing the rule text. We'll take a break about 60 minutes into the meeting, and we'll break for 5 minutes. And then we'll pick back up and review more rule text. That's hard to say. And then we'll do closing comments. I'll pause after every section so that Abby has an opportunity to go ahead and review any comments that come in, and then we'll be able to answer any questions as well. So as previously mentioned, at the beginning of each meeting, we will start by reviewing some standard group norms that will help guide us throughout our time together and help ground us in the work we'll be focusing on tonight. We want to allow opportunities for all voices to be heard. We want to remain focused on the scope of the RAC, be open for respectful discussion, encourage and honor individual perspectives and truths, use the raise hand function or chat for comments, practice active listening, and seek commonality. I want to briefly touch on the family child care RAC scope. So this RAC will help us identify any fiscal impacts, which are resources needed to implement the change, any equity impacts or unintended consequences that may impact specific groups or communities, unclear rule language, and any unintended consequences as a result of the rule change. And then if you could help us identify any additional resources that may be needed to support the implementation, that would be wonderful. As we review the rule language, some guiding questions that relate to the RAC scope are the rules identified as having a fiscal impact accurate, and are there additional resources that may be needed for implementation? Are there any unintended or potentially negative impacts to specific groups or communities? Is the group language the rule language clear enough to understand the intent of the rule? And are there any unintended consequences of the rule change or addition? As a reminder, this rack structure is a little unique since we'll be reviewing both the registered family and certified family rule sets at the same time. Given the amount of information that we'll be covering, we'll be reviewing the rules in order they appear in the draft notice that I included in my email. And as you may recall from the last meeting, many sections of the rules look exactly the same between registered family and certified family rules. But it's really important that the entire rule set is reviewed through your lens, since each of you have a unique perspective on how these rules may impact you. As you recall, the rule notices have been highlighted with many of the key changes. However, not every new rule is highlighted, and some of the highlighted rules may fall into multiple areas of consideration. So that's another reason that we'll be reviewing the entire set. In the next couple of slides, we're going to be reviewing some key changes based on the feedback from last meeting. Please know that we're continuing to review the draft rules internally, so many of the grammatical or spelling errors you may observe have already been addressed. In addition, if rules have been removed from the draft set, you'll see a strike through on the rule text indicating that removal, but I'll make sure to highlight any of those changes during the meeting so it's not lost. So if there are no other questions, we are gonna start with the feedback from the previous meeting. So we started reviewing the definition section. For the guidance, the definition of behavior and guidance, the suggestion was made that we consider changing the term self-control to self-regulation. We took that feedback to the rule-making committee, and the wording in the definition will be revised to reflect that suggestion. So self-control will be changed to self-regulation, since that more accurately reflects the intent of this definition. One additional one was the definition of play yard. It was discussed, and the feedback received was to use a common term such as pack and play, or to define safe sleep equipment and include examples, since the term play yard is rather broad and may cause confusion in the field. So when we took that back to the rulemaking group, we found out that the brand names of products are not typically placed in rule. However, CCLD does have a guidance document that shows what is meant by the term play yard as a piece of infant sleep equipment. And those guidance documents will be available to providers prior to the rules going into effect. So there'll be a clear picture indicating what exactly is meant by that definition. Under the definition of serious injury, the suggestion was to change dislocated bone to joint dislocation, and that change will be made in the rules as well. One other suggestion came in via the feedback form, which thank you for using it, and it had to do with the definition of supervision. So what we're going to do is we will address that when we get to the supervision section, and we'll be able to go ahead and make sure that the concerns that were voiced are addressed in the rules. If not, we can go back and make the changes to the definition at that time. So now moving forward to the application section. Under the application section in the certified family rules, where it explains the fees that need to be submitted with the application, there was a comment the term certified space is confusing. And the suggestion was to take the language that is used in the application instead, since it's easier to understand. We will not be changing the wording in the actual rules, since the term certified space is used in statute. For your reference, the statute number is 329A.275 if you want to double check that. However, the application does use slightly different language that may be clearer to understand. So please refer to the application wording, or you can always reach out to your licensing specialist or CCLD in general if you are not a provider, if you have any further questions in terms of needing clarification of what's intended with the certified space. Under the registration and certification process section, where it states representatives involved in licensing process must have immediate access to all areas of the home, which includes records of children enrolled in the certified or registered program. The concern was raised that this rule may be in conflict with the rule that allows for off-site record storage. The suggestion was to reference the off-site storage rule, and a cross-reference will be added that reflects that rule, and that is the OAR 414-360-02552. And lastly, we did have a question about, it came in the policy section, and it has to do with suspected discrimination and whether or not this rule changes CCLD's current practice on how allegations of discrimination are handled. The intent of this rule is actually to provide clarity to current CCLD practice, but it does not change the way CCLD currently responds to complaints or allegations of discrimination. So if there are no questions on the information I just presented, I know I went really fast, but I'd like to transition us into reviewing the actual rule language like we did at the last meeting. The information I'll be reviewing is in the rule notice that I emailed to you all. And like last meeting, we'll review each section of the rules, focusing on equity and fiscal impacts, as well as unclear language. We'll begin with the registered family rules, and then we'll review the same section of the certified family rules with a break in between for questions. As previously mentioned, many of the sections we'll review are exactly the same between registered family and certified family, but it's important that each rule set is reviewed to ensure there are no questions or concerns about the proposed requirement. We will be monitoring the time for each rule section since the opportunity for verbal comments may be limited. If you're not able to provide your opinion, please use the feedback form. I'm going to keep pushing that feedback form that has been included in the emails that I sent you. We do review each piece of feedback received either through the feedback form or verbal comments provided during the RAC meeting, and each hold the same weight of importance. So if there are no other questions, I'm assuming no, Abby? Okay. Let's see if this works. And here we are. So we are gonna start tonight with the children's records section. And so for registered family, actually, I'm going to start with registered family. We do have updated templates for the children's enrollment and authorization that providers can use. However, you're not required to use any of the CCLD forms if you don't want to, but please know that those are an option for you. And all of the items that we're going to review will be in those records that we can offer you. I do want to highlight one aspect here. We did put in, as this note states, we're stating in rule CCLD's practice of allowing records to be stored electronically now. Before that was, am I sharing my screen still? Okay, good. Just wanted to make sure.
Yes.
Before that was a CCLD policy, but now we took that policy and put it into rule.
There's one question. I
Yeah,
believe Angela has her hand raised.
yeah, Angela.
Hi, thanks. I was curious. I noticed in this, so you say electronic format, which in my world, like in my regular day job, an electronic, the very last part of that says including a parent signature. So electronic format plus parent signature, like, are you looking for like an e-sign kind of thing? I was kind of curious about that. And then I noticed in the next section, you actually defined electronic format a little bit. You said, it was like via text message or email or something like that. I wondered if it would be helpful to bring that same detail up here just to clarify what is an acceptable electronic format.
That's a great suggestion. Um, Abby, I don't know if we have specifics in terms of the e-signature.
I do not. I definitely think that's something we could take back to the group is the suggestion of identifying either what we mean by signature specifically for any sort of electronic format.
Yeah, thank you. One additional rule that I'd like to highlight is the verifications that parents have received a copy of the provider's policy. So that can look multiple ways. You can have parents actually sign a form. They can text you a response. You can go ahead and provide either paper or email or electronic, just so that there's an acknowledgement that they received it. And however you would like to receive that verification, that's up to you. Are there any other questions about this section for registered homes? Yes, Amanda.
Hi, I was just wondering if there is a need for those who decide not to use the forms that you guys have on record. Do their forms have to have the same information?
Yes.
And am
Yes.
I just missing it here in the rules?
Well, if they need to have all of this information, they can choose to use our rules if they want to, or our forms if they want to, but if they want to create their own, they can do so as long as all of this information is captured in the form.
Okay, I was just wondering if it should be maybe if people can probably figure as much. Sorry.
Oh, no, that's a great question. Fernanda.
Yes, also, as a provider, when you are opening in your home a licensing, the person that comes and license you, she reviews the contract with you to see that all these things are there, and they will let you know if something is missing, so you can add, and then you need to send it back until you got the approval before you get licensed. So I just want to clarify that just in case somebody misses something or they don't understand, there's also that a prior step before you open, and they help you with that.
Thank you for bringing that up. Okay. Now I'm going to switch to the certified. And you'll see that they are exactly the same. But I'll have you guys just quickly glance through to make sure there's nothing else that stands out. Or if you have any other questions, please raise your hand or put it in the chat.
So, Carol, there is one question from Amanda that says, does there need to be permission for field trips? And Amanda, there is a yes, and there is a section specifically about permissions that I believe we will address today.
Yes. Okay. So I'm going to move us on to the next section. So this is a new section, and it's just cross-referencing the immunizations for the Oregon Health Authority. We have a section now. I did want to highlight that a provider may provide care for a children who are in foster care or experiencing homelessness while parents, guardians are taking necessary actions to comply with the immunization requirements of the facility is both a new rule, and it's an equity consideration as well, so that we're ensuring that children of families who are in transition do have an opportunity to go ahead and have a childcare placement. Angie?
So when I'm reading this, I do have a problem with the equality part, because we are excluding like a father who just got custody of his children, or a mother who just got custody of their children, or a grandparent such as myself who got custody of a grandchild. So I wonder if maybe we could word this to be more inclusive.
Are you talking about number 2?
I am talking about
Okay.
number 2. Yeah.
Okay.
Because it's very, very concerning only to that it looks at foster care or homeless families, when there are families who could have an exception to that, such as just getting your child, you know, from a domestic violence situation,
Right.
a grandparent who's receiving their child. I'm not homeless, but I did receive my grandchild who did not have their immunizations up to date. So learning that my child could be excluded, that might be harder on some other parents or grandparents. So can we look at people as a whole, or the child as a whole, and maybe include more into this?
So are you suggesting kind of broaden this rule to be a little more inclusive of different situations?
Correct.
Okay, that's wonderful feedback. Are there any other comments? Oh, yes, Abby?
Oh, someone else has their raised hand too. I'm not sure who. Oh, it was Angie, I think. But so just when Sarah says that she appreciates number 2, and I just want to add a comment that the immunization reporting requirements for registered family have not changed. So registered family just has to have the documentation of immunizations on file, but they do not have to report that to the local county immunization office. So just wanted to make sure folks know that the requirements for registered family have not changed.
Okay. And the certified home is exactly the same as registered. And Abby? Oh, no,
I do.
Angie.
Well, and I wanted to read, Angela has a comment, maybe verbiage something along the lines of children who are experiencing a change in guardian or permanent residence. Just a suggestion for number 2 here.
Okay, good. Thank you. And Angie?
Again, I'd just like to broaden that to have it more inclusive to other families.
Great, Angie. Thank you. It sounds like there's a lot, that's a very popular opinion. I like that. So Danny?
I just wanted to clarify, so obviously I don't have OHA's OAR in front of me at this exact moment. Maybe I should look it up. But the way that this is still playing out in CF and CC programs is that you're required to have that, but exclusion day isn't until January. So as providers are following that rule by having any documentation, they do have And children can't be excluded from care until exclusion day unless the program has a specific policy around immunizations of their own. Correct or not correct?
Abby, I'm gonna let you.
I am not well versed in immunization rules and requirements. I would actually have to look them up. I know about the reporting requirements, but I do not know all the OARs, but that's definitely something we can look up. And we would, as CCLD, would really rely on OHA's guidance on their own administrative rules.
Mhm. And Angie?
Sorry, I forgot to lower my hand.
You're fine.
It's been a long day.
Oh, you're fine. Annalise?
Yeah, I was just gonna say, I think that it would be helpful, since there is a bunch of room on this page, to maybe print some of the OAR 333 050, because for English speakers, it may be an issue just to go find the OARs. For people that speak any other language or want to read in any other language, they may not be able to translate the page that they find the OARs on. And I just want to also raise that when you search for OARs, unless you specifically know to go to the Secretary of State's website, so even if you just put the website here and a link to those OARs, when you Google those, you can find non-government sites that are maybe quoting OARs that are 2, 3, 10, 15 years old.
Mhm.
And providers are finding old OARs. So I would just suggest, my suggestion would be that if you're going to send people to an OAR, that there's a link there that they can Google or they can find that is going to take them to a reputable site with updated rules, and not send people on a search to try to find those OARs in their own language and that are the current updated rules.
Thank you. So if there are no other questions, I'm gonna move us on. So now we are gonna go ahead and review the parental permissions. So this is registered family. You will find that certified family is quite similar. And this talks about what permissions need to what permissions parents need to provide. I do want to call out one equity down here. If a family served by a provider is experiencing homelessness, you can go ahead, the provider can go ahead and accept electronic or text message or email, verbal, until they can go ahead and provide something in writing. And Sarah?
Hi, thank you. My question is about 1B. Is there a time limit that these permission slips are valid for? And then that kind of goes along with the regarding field trips and bathing. Is it like a one and done, or is there because I know some others have 12-month limits.
Right, and I'm gonna let Abby answer that.
As some do have 12-month like allowances for permissions. And then for certified family in particular, oftentimes these permission or signed permissions are reviewed at or are included with enrollment paperwork, which is required for certified family to be reviewed annually, which was on and by a parent. And they have to either initial or sign or indicate that they have reviewed to ensure that all of them are still up to date. But other than that, there are no specific, at least currently, there are no specific like timelines on these parent permissions. If you think there should be, we'd be happy to hear about that. Yes.
Laura?
I think it will be a good idea to have something that state when that period is gonna end. And it doesn't have to be 12 months or 6 months, or you can put it on renewal, to the next renewal, because we know RFs renew every 2 years, if I'm not wrong. So then they can be, by the time of renewal, they need to be updated or something like that. So then it's just clear for them.
Okay. Now switch us to certified home.
There are also just a couple of comments in the chat that I'll read before you start.
Okay.
Carol, Mindy says that I update mine every year with parents. They have to date and initial the enrollment form and make changes if needed. And Sarah mentions that or state that they are for the duration of the child's enrollment. That's another option as well.
Okay. So you can see the certified home is quite similar to the registered home as well. Flora, is that a new hand or? Okay, thank you. Great. Okay, if there are no other questions or comments, I'm going to move us forward. And we are gonna, we do have arrival departure, arrival departure section in both the registered family and certified family rules. These rules align with all other rule types, the child care center rules. And so we went ahead and aligned them. And it basically is just putting parents on notice that they have to go ahead and actually walk the children into the home prior to leaving. So yes, Annalise.
I just want to raise an issue that comes up. I would say probably twice a month. I or another union member get a call on your 02352. A provider may only release a child to a parent or another person named and identified by the parents. Occasionally, and I understand may only release a child to a parent. I get that the parent who is not contracted and they're not married maybe, but the way that reads is a parent may only release a child to a parent or another person, the parent or another person named and identified by the parent. So I think what we do, I think I'd like to see that rule broken out into a provider may only release a child to a parent or may only release a child or something like that, right? Or I maybe like a 1 and a 2, right? So a provider may only release a child to one, a parent, or B, another person named and identified by the parents, because the way that reads, sometimes parents and sometimes police officers are not real clear on what that means. and a parent showing up that is a non-custodial parent that does not have a contract with the provider, sometimes a custodial parent who's trying to withhold a child from a non-custodial parent, but that a parent has visitation or whatever, that parent shows up, sometimes there is a misunderstanding about what that rule means. And it becomes clear as mud as to what that provider is supposed to do. Do you know what I mean? Am I clear about that?
Well, so I guess I'm not exactly clear how separating it out into two different would change the context of
Okay, so
of
here's what
the rule.
here's what happens. A parent comes to a childcare program. Let's say it's a dad, right? It's a dad.
Mhm.
I don't want to pick gender here, but we'll just mean for example, or maybe it's a grandparent who has custody of the child through DHS. Okay, we'll use the grandparent DHS situation. So the grandparent and DHS have a contract with the provider to provide care. The child is in care. The non-custodial parent who currently does not have rights beyond supervised visit shows up to pick up the child.
Mhm.
The provider technically would have to under this rule, may release a child to a parent. Even though and nobody else has been identified by the parents. So if this is a foster parent situation, DHS is possibly identifying. So there's another like a little loophole there, right? Because most foster parents don't fill out the enrollment paperwork. DHS fills out the paperwork and they put the foster parents on there. So if the parent shows up, it can cause a real problem. And if you've got a parent who's standing there with a police officer saying, I don't want my child picked up by this other person because and the licensing rule is that my child can only be released to me, the parent, because I'm the only parent listed on that form.
Okay.
Right. And so sometimes parents use it to stop,
Mm-hmm.
To stop the other parent from being able to pick up because that parent hasn't put the other parent on the form.
Mm-hmm.
But then also
Mhm.
identified by the parents, sometimes it's not the parents that are filling out that form.
Okay.
So there's kind of two little issues there.
Okay, we'll go ahead and we'll take that back to the rulemaking group and go ahead and look into that. Thank you. Angie?
So we're going to go back to number 2, where it says a provider can only release to a parent. I think that we need to put parent or guardian.
Okay.
The other thing is when we go back, like Annalise had said, sometimes Children's Protective Services are involved. We are required to let those children go with an approved transportation person by CPS for visitations with parents. If we're going to go off this rule, it would say that I would not be allowed to let the children go with their driver because it wasn't identified as the person. We don't always know who the driver is going to be from time to time, but they do have to show us identification. So I think we do need to maybe break this rule down so it's really clear for all of us who we can release to, and that a parent is not only just a parent, it should be guardian or a person who has custody of the child.
Okay. Thank you, Angie. Vanessa?
Kind of along the same lines, I have had to release custody or release a child to CPS because I've had to contact CPS. CPS came immediately to my house and CPS took the children from my home from the parent. So this rule, I would not be allowed to release that child to that CPS person without getting a valid finding on my license. So
I'm gonna have Christina jump in here, Christina Austin, really quick to go over some kind of the policy with CCLD and how that end of the process kind of works. If you would, Christina, are you available out there?
Yeah, I'm here. So I think there's and Abby put in a great thing, but about what parent, the definition of parent, and I think that's important to note. I think when you talk about an authority like CPS getting involved, those actions, like we would not cite a provider because CPS came and took custody of a child, right? Like that our procedures or our policy we wouldn't do that because it's not about, you're not violating a rule in that case. You've got Child Protective Services kind of supersedes, if for lack of a better way of explaining it, they have authority to protect that child, and if they need to take that child into custody to protect them, they're going to do that. We would not be holding a provider accountable for that. Does that help, Carol?
Yeah, thank you.
There are a couple things in the chat too. Mindy states grandparents, aunts, uncles also pick up at times, and that she gets it in writing if someone else is picking up that isn't authorized on the enrollment form. Sarah mentions that maybe say an authorized person listed on the enrollment paperwork, and of course people can be added. You also can't, Danny says you also can't withhold a child from a parent who has legal rights to their child. It's sticky at best. Yes, it can get very complicated. I did put the definition of parent into the chat just so folks had it. So parent, and this is from the rule set, parent means a child's parent, a guardian, or a person 18 years of age or older with supervisory responsibility of a child in the absence of a parent, which could include, grandparents, aunts, uncles, foster parents, things, those individuals of that nature. Annalise says that, sorry, the chat moves as people put more in. It gets really complicated, and Delk might be surprised how this is collaterally used, or in parentheses abused. When this is happening at the door, there isn't time to refer to the definition section. The provider is technically violating the rule. That the state wouldn't cite the rule, that's a slippery slope. I appreciate the slippery slope. It is impossible in many cases for the provider to broker these situations. And how can we expect providers to try to figure out if someone has legal right or not? So we have a lot of information to take back, and maybe get some legal guidance on this as well. So
yes, thank you. And as you can see, the arrival departure for certified home is exactly the same as registered. Yes, Annalise.
Yeah, I just have one more quick comment about that. The other thing too is that sometimes these situations get very heated. Then the police have to be called and all kinds of things. And so I just want to call out that at a center, while that's not a good thing, there are often entryways, or this is being conducted in common areas where children are in, other rooms, and they're not accessible to that chaos.
Right.
Confusion. And in a family childcare, these are people that are coming up to our front door where children are likely to be seen and heard, or see and hear things. And so just think that we just need to consider some more around that and what that means, and not put providers in situations where they're having to try to do something in a moment where they don't have the ability to go pull their rule book down. Do you know what I mean?
Right. I totally get that. And that's not our intent.
And just one comment in the chat. Mindy says that daycare providers don't or shouldn't be involved in domestic issues.
So now we're going to transition to caregiver records. So again, the records, you can have them in paper or electronic format. And the CBR confirmation letter sent to CCLD to the provider, and if the provider does not yet have a CBR confirmation letter for the caregiver, the provider must have written documentation the provider has verified with CCLD that the caregiver is enrolled in the CBR. So this pertains to personnel record for a substitute provider. So basically what you can do is if somebody says, yes, they are enrolled in the CBR, you can call our central office and they will go ahead and give you a verbal verification. Once you receive the CBR, you link them to your home, and then once you receive their CBR notice, you can place it in their file. Two other things that you would want to have is the first aid CPR training and the current food handler certification prior to serving or preparing food. These have expiration dates, so that is one reason why they should be in a file. The next section we go on to will cover some other additional training options that are training requirements that they need to go ahead and have taken prior to subbing. So I think that's more detailed list of training requirements for substitute providers and their orientation. We'll review that in the next section. So Fernanda.
I just have a question on how the first part of the rule that says that we need to maintain current personnel record for substitute providers. When we use the program with Western Oregon University, that is the substitute care program, that they make all the papers for them and we are subscribed in their program, do we also need to keep those records? Because I know a lot of programs around here, and I guess around Oregon, that are using the substitute program for getting substitutes. So I think if I'm reading this rule and I have this program, I'll be wondering if I need to align with this or not, because Western Oregon University is the one that handles the contracts with them and all the paperwork and all the trainings and all of that. So it was just a question for me reading this rule.
Yeah, that's a really good question. My initial take, and Abby, please correct me if I'm wrong, is that if they are from the substitute pool, they've been vetted, they have all their training, they have all the necessary documentation, everything like that. What you would do would be to indicate that on an attendance log that states that the individual's names and where they were from. But Abby, correct me if that's wrong.
I know that this was addressed in earlier discussions with CCSO, that is the Child Care Substitutes of Oregon. And I'll have to get back to you on it. I will double check with another colleague of ours, Ronnie Pham, who worked with them specifically around the staff file and caregiver file requirements. And we'll just have to get back to you on it. Because I'm sorry, I can't remember offhand what the decision was on that.
That's a great question. Thank you. And so the caregiver records for certified family, they do look a little bit different because they need to have, you need to have verification of education and qualifying work experience. That shows that the person meets the qualifications for their position. So that's a little bit different than the registered home. Here is the part about the CBR and how to go ahead and navigate that. And then they do need the current first aid CPR food handlers. We did strike out driving record. And then we do have the evidence, the participation in an orientation, and that a statement's been signed and dated that states that they have access to the provider's policies and the rules for the certification of certified family childcare homes. Any questions on the certified family? Yes, Sarah.
I know on the next section, it talks about how long records should be retained for. If there is records outside of that selection, is there a requirement for retention? That's a question that I get quite a bit.
Let's hold that question until we get to the section, okay? Is there anything in the chat, Abby? Okay. So here are, this is for registered family, and this covers the program records. Again, CCLD has a template available for these records, for this requirement. You can maintain them either in paper or electronic format. And then one thing I do want to call out is this is a new rule about substitute provider, including their name, date providing care, and arrival and departure times. That does come under the attendance records. And then there are some new requirements about the documentation of administration of medication. So here are all of the requirements. Again, CCLD has forms available for providers to use that cover all of these requirements. So they're not having to create forms if they choose not to. This written record of suspected child abuse, that is one of those confidential pieces of information that you do not need to provide to parents. Are there any questions in this section? Yes, Amanda. You're muted, Amanda.
Sorry. Yeah, I know. I
That's
was trying to get to the thing. I clicked on the wrong thing and
You're
yeah.
fine.
Sorry about that.
Uh,
So I was just wondering about if there are cases, or if in the case, like the provider is the one that has like a allegation made against them, if they need to inform parents about that.
So can you clarify what your question is?
I can try.
Okay. Just want to make sure I understand.
Yeah, so in the case of like if someone were to report a provider for an incident that happened in the childcare,
Mhm.
and there's an investigation because of it,
Mhm.
is the provider required to give the parents information about that if they're still open and running? Like
So-
if they still have kids coming into their care, do they still
Okay.
need to provide the information to those parents if there's an investigation going on?
Okay. So with if an investigation is closed, so a finding's been assigned, that information is on our child care portal that is available for parents or anyone to view. That's through our agency. Additionally, if the finding was if it was a valid finding and it was a serious valid finding, providers are required to post the letter on a bulletin board or somewhere that's visible for parents to see. And they need to have that stay posted for 12 months from the finding date. Does that kind of help clarify a little bit?
Kind of, yeah.
Okay. And so the program records for certified homes, they haven't changed a lot from the existing rules. So you can see that there are a couple additional requirements, such as the current week's menu with substitutes recorded.
And Carol, there is one piece in the chat that I want to say.
Oh.
Mindy just mentions that providers should be transparent. I think that was in response to Amanda's last comment.
Mhm. Are there any additional questions with this section? Okay. Move the slide. There we go, Sarah. We're at records retention now. So, what can you remind me what your question was again?
Any records outside of those that are listed here, is there a retention policy for those?
No. Not in our rules. If other agencies may have retention policies or something like that, that may be it, but for us, these are our for CCLD, these are the ones. So I do want to call out about the vehicle records. Those include safety inspections for vans designed for 10 or more passengers that were manufactured prior to 2010. And then I do want to call out some of the requirements. If using electronic records, you must have procedures in place to ensure prompt access, including an on or off-site electronic backup method to ensure access in the event of data loss. Yes, Sarah.
Question about number 4 is electronic records must be portable for use of emergencies. Is that regarding all records or just children's records, staff records, program records, etc.?
That's a good question.
That is a good question. And I know you're probably going to run it by me. And my answer to that is, we'll have to go ask.
You guys are making us think tonight. Yes, Vanessa.
I just want to make sure that there's somewhere in the rules regarding number 2, a provider must make all rules required by these rules or all records required by these rules available to CCLD at all times. There was a rule previously written where we could store things off-site after a certain amount of time. Is that rule still in these rules?
Yes. Yes, it is. And I did address that at the beginning. It maybe was when you were coming on, because I did address that. We took that suggestion from last session and we made a cross-reference. So the two do cross-reference each other.
And I'll also mention, I think that rule also about storing records off-site is specific to certified family who are required to keep records longer. So they're required to keep records for 2 years. And so I think that rule, you will see that rule on the next page or on when we get to the certified family about that as well. But Carol is correct. We do cross-reference between readily available at all times and then to the record retention rule as well.
Yeah. So. And Kristen?
I'm just wondering if there's an easier way to write this, so I'm not having to go look up like, after the initial creation for the program records identified in OR, I mean, isn't there a clearer way to just put this on here and so I don't have to go look up this rule? We don't have to, like, what is OR? If I was just reading this and maybe I don't make sense. I'm just saying, is there an easier way to have what this means? Like after initial creation for program records, what is that?
Okay, so not have the cross-reference or explain what the cross-reference is.
Explain what the cross-reference is as well. So if I'm just
Okay.
looking at this and I'm reading through my guide, I'm not having to go look up, I have to keep going to referencing other things that should all just say it right here, like reference an OR and then what that reference is. It would just seems like it would make it a little easier for people to understand exactly what they're asking for.
Do you
if
think
that
if a
makes
temp,
sense.
if a template or a guidance document was created, would that help clarify?
Yeah, I think so.
Okay.
I mean, just something a little bit more than just throwing these
Okay.
other rules that then I got to go find those to see what I'm even, what records it would just be nice if it was plain, like you need to keep this, this, and this for
Okay.
this amount of time.
Okay, great. And Sarah?
Somebody mentioned something that sparked a suggestion for number 4 again. Electronic records must be portable. Is there a duration of time, or is it excluding the records that are listed above? So is it all records ever, or just records of children currently in care or current policies and procedures? Just something to consider.
Okay. Thank you. And Angie?
So I'm going to kind of piggyback on all these OIRs. In the moment, if we get to the wrong website again, like Annalise said, we're getting wrong information. It would be nice if you guys gave a clear definition of what the requirement is and then said something for further information or more defined, please visit OIR 414, blah, 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 and give us a link or give us the site that you've referenced so that we know that we're getting the correct information. But this doesn't make any sense to any of us. And I'll be honest, I don't have time to look up every OR that you guys are wanting us to look up to figure out what our rules are.
Okay, thank you. And Vanessa?
To add to that, including a page number so that we don't have to go to look up OAR 414210025. We don't have to go back to the content table of contents, find where that rule is, flip to that page, if that makes sense, because a lot of times, as providers, we're in the moment trying to quickly look up a rule. We don't have time to flip to 15 different pages to get that information that we need in that snap minute. So including a page number to that rule next to it would help too, because then we can just flip to that page.
The difficulty with that is sometimes we get new federal requirements or we get new requirements that we have to go ahead and put into the rules, and then it will throw all of the page numbers off. So it does create some complications to do that. But Abby, I see that you have your hand up.
Oh, I there are things in the chat.
Okay.
But I also want to just call out that I have the wrong division number in E. It says 360. It should say 210. But Vanessa says that's a great point, Kristen, that especially when we're trying to look things up quickly, but end up having to go back and forth. And Mindy says the problem with that is that there's so much information and rules, it would be thousands of pages long to list all the rules. Yes, and they're long enough as it is. Sarah says, license rules in Minnesota does this includes links across cross references. It's a lot of work to keep up with, however. And Sarah, thank you for calling that out. We're sometimes restricted in what we can put in rule and can't put in rule. For example, it'd be really difficult to put page numbers because we couldn't put that in rule, right? But we can probably make the rule book itself more useful, which may be able to include either links or page numbers or something like that. But we definitely hear you on the fact that like having to look up at different OARs is time consuming and challenging. I just, wish the rule could just say you got to keep all your records for 1 year, because that's essentially what this rule is saying in a very long and kind of tedious way, right? So we definitely hear this, and we'll take it back to see if there's a better way to make it cleaner and clearer, and maybe just more concise about what records are required to be retained for that 1 year timeline. And then do we have these rules in other languages to help bilingual providers? And the answer to that is yes. RF will be published, Register Family will be published in, oh gosh, more than the routine 5 languages. I believe there were several other languages included, but at a minimum, they'll be in Spanish, Vietnamese, Chinese, and Russian. Certified Family will be, I think we currently is in English and Spanish, but there may be looks to expand those as well. But we do translate our rules.
And we'll take Floor's question, and then we'll take a break.
Okay, I will be fast then. Just, I mean, I know we like to have the book, right? And we cannot add all these things because it will become a Bible. But maybe if we have the option to have it electronically, so if I'm working and I need to check the rule, I can go to the book and look really fast, but then maybe later on when I have time, when it's nap time, I can go to the electronic one, click on the link of the exactly thing that I'm looking for, and then boom, it's there. So that might be a way to make it a little easier, no more accessible, but at least a little easier and faster for us to find the right information at the right moment.
Great, thanks, Floor. So with that, let's go ahead and take a 5-minute break. So if you can come back at around 7:15, that would be great.
7:15?
Well, it's 7:08.
Okay. 7-minute break then.
7 minutes.
Sorry.
Unless it's easier to do
That's
the
fine.
15 then.
7-minute break's fine, of course.
With items that are available for review. I am going to have to scoot us through a little bit quicker because I want to make sure that we cover all the information. And I want to be respectful of your time and make sure that we end on time at 8 o'clock. So please feel free to put stuff in the chat or use the feedback form if you don't get an opportunity to go ahead and provide your input verbally. So in the registered home rules, we do have a new section called items available for review. This first rule states what needs to be posted. So the most current registration, serious valid complaints or serious non-compliance letters, any notice of a current or pending legal sanction, and that a notice that the items listed in 3 down here are available. I do want to point out that 3, the requirement, we do have a template for this requirement, and all those items need to be available for review, but they can be stored in a binder. They don't have to be posted. One additional change that I would like to bring to your attention is the little B. This rule will be moved to what is included in the list of items under number 1 that need to be posted. And this is for just parent communication and transparency. Yes, Sarah.
A suggestion would be to make 3F a required posting instead of in a binder. Letting parents know they're welcome in the childcare facility.
That's a great suggestion. Thanks. Are there any comments in the chat, Abby?
There's one about just requesting that our rules be translated into Somali and Arabic. And then, but no, Annalise does have her hand up though.
Okay, Annalise?
Yeah, I was just gonna say, to follow up on that previous comment, and you move the screen a little bit, so now I'm trying to figure out where it's at.
Sorry, I think
No,
it
that's
was-
okay. Okay, that F, that 3F.
Right.
I would suggest some clarity on this, because this is, again, this is a comment or a question that I get a lot as a union steward. And I know our other stewards and peer advocates get this a lot. And so I think it's fair that a custodial parent has access to the childcare areas when their child is in care. But I don't know that they need to have access when their child is not in care. Do you know what I mean?
Mhm. Okay.
During hours of operation, here's the thing, right? Hours of operation. I mean, I'm a 24/7 program. If a parent wants to come in and take a look at my daycare on Sunday afternoon at 2 o'clock in the afternoon,
Mhm.
I mean, I'm going to tell them no, not unless not unless their child is here.
Mhm. Mhm.
Right?
Mhm.
Because this opens me up to where, and here's how it'll be used, right? So this parent says, well, I wanted to come in and, and do this and be there and hang out when my child wasn't there or whatever, right? Wants to see something or whatever. And they come to me and they say that that's what they want to do. And I'm trying to be helpful and I'm trying to be there for parents, but I also, if I don't have any kids in care, I really need that downtime.
Mhm. Mhm.
And that's time off for me. And again, this is one of those rules where some parents will complain. And I also understand, that when parents complain because they're never allowed in the child care program, I see those complaints come through, and licensing investigates those complaints, as they rightfully should. So I just want to parse that maybe there might just be a little bit of clarity that's possible there to reinforce that, because I think the law, really, the intent is that parents have access to all areas of the child care when their children are present.
Right. Great. We will take that feedback back to the group and we'll look into that. Thanks, Annalise. Abby, are there any questions or comments in the chat?
Mindy just says she agrees, and I believe that was just with the last comment as well.
Okay, great. And again, there are a couple additional requirements for certified homes. You need to have the behavior and guidance policy, emergency numbers, and a daily schedule, and then the current week's menu. Yes, Annalise.
Yeah, so this is one that I think we had talked about too when the union met with Delk. When, in between the work group and the RAC. Our union would really like to see that rule changed from a daily schedule to a daily schedule / routine, because if you operate an infant toddler program, and you're following the rules of putting the children's needs first and seeing to those children's needs, there is no way to have a written schedule.
Right.
You're never going to follow it.
Right.
Right. So I think that needs, and I get it, right? But that there might be situations where you don't enforce it. But then if you have a rule that you're not enforcing, or you're not enforcing all the time, right, then maybe that's not the right rule, because if there's a rule and there's a situation where you can't enforce it, then that I think undermines the validity of the rule itself. So
Okay.
I would encourage daily schedule or some sort of routine,
Okay.
the word routine in there, so that gives the licensing staff and the compliance staff room to move.
Awesome. Great suggestion. Thank you. So I am going to move us on to the notification section. So I want you I want to call out that there are different timelines here. So these requirements are you must notify CCLD by 5 p.m. the next business day. We did have a definition of business day, and we reviewed that last session. So we'll have you go ahead and review this list, if you would. Number 4 covers immediate notification to parents or an emergency contact if the parent cannot be reached. Yes, Annalise.
I was just going to say, given the HB 4086 work that's happening now, and all the myriad considerations that are going into that process, is there any thought to defining, and I think you scrolled down past it, or no, it's right there. Suspected physical, sexual, emotional abuse, child neglect, child endangerment, child exploitation, inappropriate sexual contact between 2 or more children. That inappropriate sexual contact between 2 or more children, that needs to be defined, and there needs to be some guidance.
Okay.
Because what is inappropriate, right? There is a legal definition of what is inappropriate, but then there is also several cultural considerations there. And the cultural considerations are not necessarily going to be taken into account by the investigatory agency and are probably not going to be taken into account by a judge. So I think that inappropriate sexual contact between 2 or more children, that needs to be well defined, and there needs to be some guidance about what that means.
Okay, great. Thank you.
Because that's a serious matter. And I've had a lot of discussions around that, around HB 4086, especially in the work that we're going to start now with that work group, because I'm in both of those work groups. There's just been some really serious issues with serious consequences or almost serious consequences for childcare providers. Sometimes things are blown way out of proportion, and sometimes things have not been taken seriously enough. So I think it can go both ways. We just need to figure that out.
Okay, thank you. Thank you for that. Any comments on the emergency contact, the immediate notifying parents? Any questions or comments come through the chat? Okay. I do want to highlight number 5. Provider must immediately notify parents in writing if a condition or restriction is placed on the license. So this requirement does take the place of having parents sign a declaration of viewing. So this change was in response to the provider feedback that declaration of viewing was unnecessary since licenses need to be posted. So we did change that requirement, but for communication purposes and transparency purposes, we put in this rule that parents do need to be immediately notified. Number 6 does cover items that the provider, you must notify parents upon child pickup of any of these items. Any questions or comments regarding this section? Okay. I'm gonna switch us to the CF. And this is the same. We have, now we put in a time limit here because before we had a requirement that they had to notify, but we put in, clarified the time.
There's a hand up,
Yes, Angie.
Carol.
Yep.
Okay, so I'm just looking where on number 4, where we're supposed to notify the parents immediately if. And I'm just reading, does not arrive on their own at the home. Instead of using the verb home, could we maybe put program? Because it might be misleading that maybe the child walked to their home, not our program.
That's a great
I-
that's a great suggestion.
And I will say that suggestion mirrored one we heard from our own staff. And I
Yep.
think in the final draft, it actually says on their own at the like registered family childcare home. So it really identifies that that's the intent. So great call out. We you are not the only one who picked that up on that one too.
You're my baby, huh? Is you my baby, huh? Taking class with me.
And this note just says the same about this rule taking the place of the declaration of viewing. And this list covers notifying parents upon child pickup. Okay. Any questions come through the chat, Abby? At all? Okay. Well, I'm gonna move us on. Yes, Annalise.
I know that the rule doesn't need to say this, but maybe for clarity, could it say that a provider must notify parents upon pickup of the following unless the parent has already been notified?
Oh. Okay.
Just, it came up this year, I think it was in March or April. And the state was in a situation where they kind of had to cite it because the parent wasn't told necessarily at pickup, had been told earlier, but it wasn't said again at pickup.
Huh. Because I would think if they were told before that they were exceeding the rule versus breaking the rule.
The
So,
only problem you're gonna well, and where this came up is dad's house versus mom's house.
Oh.
So dad or mom, one of the two had dropped off. That parent was the parent that was contacted. The provider erroneously assumed that the parent who she had contacted, who had dropped off, was going to be the parent, was going to tell the other parent. So didn't say anything to the parent. And then the parent got upset with the provider because the provider didn't tell her directly, and she or didn't tell the parent directly, and they had to hear it from the other parent. And
okay.
so I'm just saying,
Okay. Okay.
right?
Great.
This
Yeah.
would protect.
Yeah.
and this would
Great
help
suggestion.
Belk, right?
Yeah. So I'm going to go ahead and move us forward. We're going to talk about the caregiver requirements. I do want to call out number 2. They must be physically capable of performing duties related to childcare, relate to children with courtesy, respect, acceptance, and patience, demonstrate realistic expectations for behavior based on the age, abilities, and needs of children, and recognize and respect the uniqueness and potential of all children, their families, and their cultures. So, number 4, this aligns with OHA's symptom-based exclusion guidelines. We're going to review this section in more detail when we come to it. But a couple of examples would be vomiting when there's no explanation for it, fever 100.4, severe or persistent cough when there is no known reason for it, such as like asthma or something like that. Okay, if there's no questions, I'm gonna move us on here. Again, the beginning is quite similar to the registered home. So provider must ensure that all caregivers, volunteers, and household members who have supervised or unsupervised access to childcare children. And here is the list of items. Number 2 is exactly the same as registered home, which we just reviewed.
Isn't sorry. 2F kind of repetitive, considering in a previous rule it said that we were required to report all of that?
You know, I think in this section, it goes over the provider, all caregivers, volunteers, household members, so it expands that a little bit. But I don't know, Abby, do you have?
And this is just specific to the caregivers and the providers. So any assistance you may have working for you, and just ensures that they are required to recognize and report and suspected abuse, neglect, and exploitation.
And Annalise?
I thank you. I just want to call out that we do have CF providers. Not necessarily RF providers, I'm not aware of any, but we do have some CF providers who are not physically capable of performing duties related to childcare, but they certainly have enough staff to make sure that those things are being met. So I just want to say that 2B is not necessarily ADA compliant. Because if a provider, let's say a provider that the person who holds the license is not physically capable of performing duties related to childcare, that's probably okay as long as they have staff that are able to perform those duties related to childcare. Right? So I don't know that I don't know that that's really legally able to be enforced. Now, I'm not an attorney, so I can't speak, but to that essentially, but I think that that's probably a rule that might need to be tweaked.
Okay, we'll look into that. And then this note is exactly the same from registered home. Are there any questions in the chat, Abby? Okay. I'm gonna move us forward. Okay. So central background registry. These rules really didn't change much. The one thing we did add in is about individuals 18 years of age or older that reside on the premises in living spaces other than the childcare home, including but not limited to ADUs, alternative housing, tiny homes, apartments, are not required to enroll in the CBR if all of the following conditions are met. So it's A, B, C, F, G. We removed D and E. So I'll have you look at those.
I also, while people are reviewing, wanted to just call attention. I believe someone last session asked about visitors and CBR enrollment and extended family. And this is where this is covered. And when folks need to be, are required to be in the CBR as like visiting guests that are staying at the home. So they can be on the premises for under 14 consecutive days, not to exceed 30 days. Yes.
Yes, Annalise?
All right, so can I ask a clarifying question on the rule? For really it's A, right? Those residing in or visiting the living space, visiting the ADU, recreational vehicle or whatever, right? I can understand those residing in that other living space, right? The garage apartment or whatever. And with the housing situation the way it is, we're seeing that more and more. Adult kids moving back home and things like that. So I can see that those residing in because they're on the premises, they're living on the premises. I can maybe see the residing in, but visiting the living space are not suspended or have not been denied or removed for cause from the CBR. The provider isn't necessarily going to know who is who is visiting the living space. And so I'm just wondering how this plays out, right? So if you've got your adult daughter, your 47-year-old daughter moving back in, and she's living in a detached garage or an RV on the back of the property, she's never had any problem with the CBR. She's on the CBR, right? But she has a boyfriend. She doesn't realize that he was denied a CBR because he was dating some other childcare provider or whatever. You're now talking about like a third person, like somebody twice removed from the provider, potentially. And I'm just wondering how providers are going to be able to monitor that, especially if this is somebody that is not related to them and is renting from them out of financial need of the provider.
I don't know. Abby, do you have?
I think we can take that back. This was some language that did come from DOJ. So, but we will. I can see that point completely, and we'll take that and just ask if it either needs clarification, like if known, or if it can be removed.
Yeah. And Angela, you had your hand up and then you put it down. So did we answer your question?
Yeah, I just a comment on that. I mean, as a parent, I'm very comfortable holding a provider to the standard that if someone is on your premises, ADU or otherwise, you are aware of who that person is and you are held accountable for whether or not that person is allowed to be around my kids. So I know that that can get complicated, but just from a parent's perspective, I feel like that's reasonable.
Okay, great. So I see your hand, Annalise, but I'm gonna call on Danny, and then we're gonna have to move forward. If you can put your comment in the chat or the feedback form, that would be wonderful. Danny?
I want to say that I feel like if B and C are being met, like they don't have access to the children and they don't have to enter the actual childcare home, that feels sufficient regardless of CBR. Being somewhere else on the property, if you can't even have a conversation with the childcare children, that feels like far enough away.
Okay.
That the children are protected. And because I agree, you could be renting that, you don't know who's coming in to visit other people who are living somewhere else in your property. But what I feel like really matters about this is that they don't have access to the children. They're not having conversations with, being around those kids. And if they don't ever have to come into the childcare home to be where they are, that feels. So I don't know if there's a way to like word that, like if these two things are true, and if they're not, then definitely then the CBR is needed.
Okay, thank you, Danny. Again, these are the same rules. Exactly the same. Okay, if there are no questions, I'm gonna move us. Oh, did a question? Yeah. Oh, Angie.
Did that. I'm sorry. So
Oh, you just muted yourself.
of course I did. This is something that, comes up. A lot of us utilize an educational service district for children,
ESD.
with needs.
Mm-hmm.
This has been something that we've talked about. Do we have to stand there and watch them give our children, what they need? Because that really takes away from the. What is going on? Why does it keep muting me? So my concern is with like educational service districts.
Mm-hmm.
Obviously they have their own background check. They are not part of our CBR. Are we required to stand there and watch them the entire time they are, working with our kids? Because that takes away from the other kids in our program as well.
Right. And Abby,
This is actually addressed, Angie, in the section we'll cover later on a plan for of care for a child with a specific need. We actually outline that if individualized services such as speech therapy, occupational therapy, something like that needs to be provided away from a caregiver, that can happen. It just needs to be acknowledged and permission given by the parent. So yes, it can happen away out of direct supervision of a caregiver. The other thing I just wanted to there was a comment in the chat from Annalise. So from the provider perspective, if I'm doing childcare and someone walks back to a trailer, an ADU, and I don't see them and they are back in the trailer or the apartment, that's pretty hard to manage. It's not like I can leave in the moment or monitor my renter and their visitors. Plus, if they are renting, they do have the right to quiet enjoyment, and the law says they have a right to invite guests over. Seems like the law needs to change and prohibit these individuals like it does around schools and schools and such for sexual predators. And not all CBR denials or removals are of equal weight. And Denny says, thank you. She has to run, and she'll put more comments in the feedback form. Thanks, Danny.
thank you. Thank you, Danny. And Angie, is that a new hand or an old hand?
Nope, that's the kitten bumping buttons. Sorry.
Oh. So now we're going to shift to the duties and qualifications of the provider. I do want to just let you know that we have 10 minutes left. Sadly, we're not going to get through everything tonight, so we'll have to catch up next session. And I just want to call out here that we do have some requirements for substitute providers. If there's no questions or comments on this section for registered home, I'm going to move us to certified.
Hey, Yeggers, that's a lot of mess.
So I do want to call out here that we did cap the hours. So provider must be on site and actively engaged in the care of childcare children at least half of the weekly operating hours or 40 hours per week, whichever is less. And again, the same with 3. If you're certified for over 12 children, you need to be on site and actively engage in the care of children at least 2/3 of the weekly operating hours or 40 hours per week. So like in Annalisa's situation, she's 24/7. Before how the rules read, she would have had to be on site and actively engaged with children for more than 40 hours. So we did cap that. And that's something that we heard through the listening sessions, and so we wanted to respond to that from providers' perspectives. I do want to call this out. 7, we did lower it to 6. And that aligns with center rule teacher qualifications. And so this has a strike through and it's step 6.
I also wanted to call out in this section that we slightly modified when I'm trying to remember how this works. In registered family, remember, Carol, like when you can become or when you can move from, if you're applying to be a CF and your only experience is RF, we have reduced the number of hours that you have to be a CF with a cap of 12. I believe. It's a little bit complicated. I believe because it's no longer a year. I think it's 1,500 hours.
At least 1,500
Yes.
hours.
So that's for the provide. Yes. So that that has actually been shortened because 1,500 hours isn't a year. So you could potentially move from RF to CF quicker. And then you could also move from CF with a cap of 12 to a cap of 16, depending on square footage, quicker as well. So there is a quicker pathway to increasing capacity for those who come in with just RF experience. And just a comment in the chat too that Annalise says down to 6 seems very reasonable.
I have a comment on that one. It wouldn't be good to mention those 1,500 hours on the RF, just like a little note, like if you're planning to move on CF, you need this and this amount of hours, because I'm just thinking, right, if I am an RF and I'm thinking to go to CF, I'm not gonna find that out unless I go and Google what are the needs for me to become a CF. So maybe we just have a little note there that says to RF to CF, you need this amount of hours. Might be helpful.
Okay, so cross-reference. Okay. One thing I would like to call out here is we are it was, where is it? Oh, it's in under the assistance. I'm gonna get to that. I'm gonna try to push us through 2 more minutes so that we can get through another section. We are still working on some substitute provider stuff. The staffing we are still working on currently, because we've received quite a bit of feedback about that. Yes, Annalise?
Yeah, this is the section where you're planning on putting the substitute pool language, right? That exempts the substitute pool folks.
It's in here, the assistance, and I'm not certain we have 3 minutes, and I'm not certain we'll get through this section.
It needs to go back up to the former section because it doesn't really fit under assistance. It's subs, right? So I think that's in the wrong section. That's all I was gonna say.
Okay, that's a great call out. And one thing that I did want to call out here for any certified home providers, we're moving towards 60 hours at any certified home childcare rather than 60 hours at your, and that is to be an assistant too.
Just wording on what Annalise just said, because in the one at the top, we do have a substitute provider must. So I think that's exactly where all the substitute information should go instead
Okay.
of down below.
Okay, great. So I'm going to encourage you guys to look at this section again. Please use the online feedback form. There's been so much great feedback tonight. So I want to thank you again for all of your participation, for staying engaged, especially after a long work day that you guys have all been participating in. And we're going to review all of the feedback and we will bring that back. We'll bring back some key decisions next week. The format will be the same. I'll be sending out an email along with the sections that we'll review. Since we didn't get through all of the sections, we're going to have to pick up where we left off here and go ahead and work from there. And again, I'm just going to put a plug in for the feedback form. Can't plug that enough. So thank you all for those of you who have used it. It helps us out a lot with trying to kind of get some of our thoughts in order prior to these RAC meetings. So I want to thank you all for your time tonight and have a good rest of your evening. Thank you.